Welcome back to Takacs McGinnis Elder Care Law News Hour. I'm Tim Takacs, and our focus today is on estate planning, taxes, and trust as they relate to the needs of certain demographic groups. Barbara?
And I'm Barbara McGinnis. Welcome back. We're back again with Frank Cardenas and Kristy Brassell, and we're going to continue a conversation with them, but our focus is going to be different. We're going to look at non-married or unmarried couples, though, and how the role of marriage impacts estate planning and taxation and their public benefits, right? So we'll start with Kristy. What is special estate planning needs do non-married couples have, and how are they different from planning for just a single person?
Well, non-married couples, we like to recommend that they have some type of contract in place, because it's really important. And a lot of people, when they start living together, they don't think about that. But there are issues of who's going to buy the house and how that affects you tax-wise. How are you going to hold title to the house? Are you both going to be on the checking account? You're also going to need to spell out, if you have children from previous relationships, what assets are yours and what are theirs, and how do you, make that work.
So Frank, what challenges do non-married couples face in obtaining or keeping public benefits like Medicare or Social Security?
Well, specifically with Social Security retirement, and they do need to provide to the Social Security Administration a marriage certificate. So if they are unmarried, they wouldn't be receiving a spousal benefit. However, if they have previous marriages, what they need to prove is a 10 years worth of marriage. So even if it's like, say, a blended family or an ex-spousal benefit, as long as they've been married for 10 years or longer, and they can prove it with a marriage and divorce decree, they're still able to receive ex-spousal benefits, which are paid just like normal married spousal benefits. So unmarried or not, if we have that kind of issue, there's still benefits they need to look into.
So say if I believe in serial marriage, meaning I'm married several times,
Yes.
each spouse I marry, I'd married for 10 years and then I get rid of them, or they get rid of me probably.
And it's not uncommon. We do have clients that, they've had maybe 3 previous marriages that each independently lasted for 10 years or longer. So as long as each particular marriage lasts 10 years or longer, each independent spouse is entitled to their spousal benefit.
You get to pick. You get to pick the benefit that you're going to draw from.
That's right. That's right. So the rule
hopefully that spouse is going to choose the highest one. Right?
Yes, that's what we recommend them do.
Right.
And even the agency would recommend that for them as well. But if there are 2 or 3 previous, or even 4 previous marriages that lasted for 10 years, they are able to choose which one they would want to draw off of. Now, if they were to remarry, they're not able to draw on the old ex-spouse. They would have to look at their current spousal benefits.
Okay, that's a discourage of marriage law, right?
Of remarriage.
Yes, right.
And one important thing, though, with that is that if something were to happen as far as becoming a widow early in age, you do have the option that if you can stick to your widow benefit, but if you're over the age of 60 and you remarry, you can still get a widow benefit or look at your current spousal.
Right. Now, it's not going to affect the person, the serial marriage person like me, perhaps.
Right.
Which is, so people don't misunderstand.
Hypothetical.
Very important. It would
not affect my benefits in any way, right?
Yeah, for instance, if I had 3 ex-spouses with 10 years apiece, they could all drop off of my record, but it would not affect my benefits or my current spousal benefits.
Okay.
If that were the case.
All right.
What about if they have kids? This say a non-married couple that has kids.
Now, the beneficiary, whoever is the parent, if they're receiving disability retirement, they would also receive benefits as long as the child is under age 18 or 19, if still in high school.
Okay. All right. So obviously this question is going to be for Kristy, because I'm going to ask about trust. Can trust level the inequities of a non-married couple from an estate plan?
So the very basic definition of a trust is assets held by a title of property for benefit of someone else. So, a trust is a really good way if you have assets and you think that your partner, girlfriend, boyfriend is not maybe a responsible person with money. So you can put your assets in a trust, and then the trust document will determine how those are given out to the partner. So, you know, you could also do it for minor children. You know, there's all different types of trusts. Right. We usually leave the type of trust up to the estate planning attorney, and then we will help with the tax implications from that.
So you're kind of like the first line person there, that they're coming into you every year and saying, I've got this life situation, and
That's
you're
right.
identifying issues and saying, you need to really take care of this.
That's right, and we kind of want to be able, you know, the worst thing is when, you know, you get those, oh, by the ways, I already did this, you know, and so you hate to see, you know, a tax situation that you could have prevented but you can't help, you know, so we like to be able to help our clients on the front end and direct them to the right person, you know, to do that estate planning.
So we have non-married people here. So the non-married couple comes into you, and part of what you do is tax planning. Okay, so what are you going to tell them?
That's right. So, you know, one of the things that we were talking about at break is that you lose out on the marriage portability of the estate tax exemption. So right now, for 2017, I believe it's $5,490,000 per person.
So what does portability mean?
It means that if I die and my estate is only worth $1 million, I still will file that estate tax return even though I'm under that umbrella. But then I will choose the marriage portability election, which will allow my spouse to get the remainder of that. So, you know, because you don't know what's going to happen in the future. Your spouse could win the lottery or become, you know, sell a business, get an inheritance, and so they might need more than their $5,490,000.
So they take your million and
they take whatever's left, the $4 million that I had left, because I only, you know.
Yeah.
But an unmarried couple doesn't get to do that, and so that's a real drawback in estate planning.
So that's the remarriage encouragement law, right?
That's right.
Yeah, but you know, $5–10 million, that doesn't affect a lot of us. You know, what about just
that's true
annual filing of tax returns as a married versus a non-married couple?
Well, I mean, an unmarried couple is going to file single. So, you know, everything is going to be separated. A married couple has that choice to file married filing jointly or married filing separately, depending on what situation works out better for them. And most times it is to file married filing jointly.
What about gift taxes? Because part of, you know, now that I'm hearing this conversation, it sounds like, well, maybe the wealthier spouse or non-spouse could transfer gift assets to the non-wealthier non-spouse.
So
does that sound like a good idea?
Well,
or not?
I mean, to me it was really kind of neither here nor there, because you get an annual $14,000 gift tax exclusion, but then that estate tax exemption, the $5,490,000, that includes all gifts. So, you know, as long as it falls under that umbrella, you know, talking about giving gifts, for example, you know, a lot of people, like you said, don't have $5 million, but they have a house. You know, so do I want to just go ahead and gift my children my house while I'm still alive? You know, that's a real popular question. And you know, if you gift something during your lifetime, they get the basis that you have. So if you bought that house 40 years ago for $70,000, that is their basis. So when they turn and sell that, they have a gain on that difference. If they wait and transfer it during death, they get what's called a step-up in basis, and that's the value at the date.
So just before we go to break, we've just got about a minute or so. We haven't talked about non-married couples who have maybe a special needs child.
So
what about the public benefits part of that?
Oh, that's a huge one. We have to give a lot of education with. If there is a special needs child, like say even in my instance, I have a sibling who was born with a mental disability. If that child was deemed disabled before the age of 22, they will be able to receive retirement or disability benefits off of mom or dad. So that's huge for them to know, because that would change the entire dynamic about when to file for their retirement, their Social Security. So they just need to understand that if there is a disabled child that became disabled under 22, then they're able to receive benefits.
Okay.
All right, so
I think we have contact information for McMurray, Fox & Associates, as well as FedLogic on the screen. And of course, this information and others will be available on our website as well.
All right, so it's time for another break. And when we come back, we'll look at these special financial planning needs faced by women. So we'll be right back.